We will read it, but not everything. By a notice of motion dated 1st of October 2025, the applicant, who is also the petitioner, raised that this bench, comprising Gola, Rima, and Gami JJ, do recuse themselves from further hearing or intervention of any aspect of these proceedings. The applicant further seeks have this matter placed before the Honorable Chief Justice for directions and any subsequent orders deemed appropriate. In the application, which is supported by the affidavit of Joseph Enoch Aruba, sworn on 2nd of October 2025, the applicant contends that he has been subjected to discrimination by the bench. He particularly contends that the present petition has been irrationally isolated from the consolidated petitions, notwithstanding that it raises substantial similar issues as those in the consolidated petitions. According to him, such isolation amounts to a violation of Article 27, Sub-Article 4 of the Constitution. The applicant emphasizes that it is necessary to have the present petition heard and determined together with the other consolidated petitions, particularly in relation to the issue of an expended bench. He is therefore apprehensive that, owing to the apparent bias of this bench, he will not receive justice in these proceedings. He has cited Supreme Court decisions which we have noted. He faulted the bench for disregarding these authorities and established jurisprudence which underscores the court's duty to consider consolidation where petitions raise substantially similar issues. In his view, the failure to apply this settled position can only be interpreted by a reasonable and informed observer as an attempt by the court to deliberately sideline him and to entrap his petition within the confines of the rest in the better technicality. Following the directives issued on 2nd of October 2025, the bench received the responses from the various parties as well as written submissions which we have considered. The principal grounds advanced in opposition to the application are firstly, that it was the applicant himself who sought the consolidation of the present petition from Nairobi High Court petition number E565 of 2024, and that by the orders of 29th of May 2025, the court granted the very relief he had requested. Secondly, it was argued that the applicant has failed to meet the requisite threshold for refusal, that the application was sub judice and that it proceeded on a misapprehension of the Supreme Court's decision. It was further contended that although the Court of Appeal did quash the order of the Deputy Chief Justice in the Jamba and 5 others, it did not preclude the Honorable Chief Justice from issuing fresh directions reappointing this bench to hear and determine petitions. Upon empaneling the bench, the Chief Justice was rendered functus official as of 23rd of January 2025. That is the background to the matter.
The analysis and determination of the application follows. The parameters under which a judge may be called upon to recuse themselves are well settled in law and firmly anchored in jurisprudence. This bench has previously had occasion to pronounce itself on the subject in constitutional petition number E522 of 2024, consolidated. In that ruling, we were emphatic that the test for recusal is objective and rests on whether a reasonable and informed observer viewing the matter in its proper context would apprehend bias. We further emphasize that recusal is not to be invoked lightly, but only where circumstances disclose a real likelihood of bias or where justice would not be seen to be done if the judge were to continue presiding over the matter. We reiterate that position, and we have highlighted the specific paragraphs where the issue is raised. Now, the grounds previously advanced for seeking the recusal of this bench were premised on alleged and disclosed relationships with certain parties to the petitions, which it was claimed might have influenced the court to convene and sit on a Saturday with the intention of assisting one party in the proceedings. We have carefully considered the grounds of recusal raised in the present application against those that were canvassed in the earlier petition. With respect, we are unable to agree with the contention that the present application is barred by the doctrine of res judicata, noting that the grounds then and those now advanced are materially distinct. Accordingly, we shall proceed to consider and determine the present application on its merits. And we find it apt to begin by referring to the decision in Dobbs versus Tridios Bank, where the court stated and emphasized on the importance of a judge to resist temptation to recuse himself simply because it would be more comfortable or convenient to do so. That decision is quoted quite extensively. I don't intend to quote the entire portion of it. In the present matter, the applicant pleads bias on the part of this bench. To address this contention, we turn to the New Zealand Supreme Court decision in Saxby Company Limited versus Woodward Company Limited, where the on grounds of bias. The court held that the test is one of real and not remote possibility rather than probability, and is to be applied through a two-stage inquiry. So the judge must consider first what it is that might possibly lead to a reasonable apprehension, but whether there is a logical and sufficient connection between those circumstances and that apprehension. Insofar as concerns the informed and fair-minded observer, in whose eyes the potential for bias must be determined, the Court of Appeal in the Bashago and 5 others versus Mindy and 5 others and 80 others, the Court of Appeal was succinct in restating the applicable threshold. A similar position was echoed in Hub versus His Royal Highness Prince Abdulaziz bin Fahd, where the Court of Appeal of England and Wales emphasized two critical points. First, the opinion of the notional informed and fair-minded observer is not to be conflated with that of the litigant, considering that most litigants are inclined to resist anything they perceive as jeopardizing the prospect of success, even where such perceptions are not objectively found. The court also emphasized that the informed and fair-minded observer is to be treated as knowing all the relevant circumstances and not merely those that are publicly available. We do not wish to again quote the entire, that is a page or two of that whole determination. Guided by the foregoing authorities, the pivotal issue for determination is whether, in view of the matters advanced by the applicant in this present application, a fair-minded and fully informed observer, one acquainted with all the relevant circumstances, would reasonably perceive this bench as having exhibited bias against the applicant so as to justify recusal. The applicant contends that this bench directed that his petition be heard in isolation, segregated from the other petitions. What he fails to disclose, however, is that on the 23rd of January 2025, this very bench issued express directions consolidating this petition with the other related petitions. The record is clear and confirms the following directions of the court. Direction number 3, that all petitions before the court, that is under cohort 1, cohort 2, and the petitions being today mentioned for the first time, the court went on to enumerate those petitions, including Nairobi petition number E586 of 2024, which is a current petition, are hereby reconsolidated into one petition. petition number E565 of 2024 shall be the lead file. All filing henceforth shall be made in this file. How then did we arrive at the present situation where a petition that had previously been consolidated is now being considered? The answer lies in the record of the 29th of May, 2025. Contrary to submitted that the instant petition raised unique issues requiring expeditious determination by an expanded bench of judges. It was in recognition of this submission that the court reviewed its prior directions. The court concluded that the uniqueness of the petition justified deviation from the general rule and that fairness demanded that the petitioner be afforded an opportunity to prosecute his case without being held in abeyance pending the outcome of cohorts 1 and 2. These directions were not concealed. They were openly given in session, and the rationale for this was explained. For the avoidance of doubt, this bench directed as follows: in order to allow the petitioner room and the latitude to fully ventilate his case, and noting that the first interested party has indicated that he will not be participating in this petition, and further noting the previous directions issued by this bench to the effect that petitions not consolidated in the first and second cohort would await the determination of the consolidated petitions in cohort 1 and 2, we review these directions in view of the uniqueness of this petition and allow it to run on its own. The segregation of the petition was not a unilateral act, but rather a direct consequence of the applicant's own request. From a case management perspective, had the court not allowed the petition to proceed separately, it may very well have fallen squarely within the category of petitions required to await the outcome of cohorts 1 and 2. It is therefore our considered view that the fair-minded and informed observer, one who is appraised of the full procedural history, the rationale for the directions issued, and the applicant's active role in seeking deconsolidation would not apprehend bias, mainly because the petition is now proceeding.
Accordingly, therefore, we find and hold that the applicant has failed to establish a reasonable apprehension of bias on the part of this bench. The application dated 1st of October 2025 is therefore dismissed. Parties shall pay upon course.
Much obliged. My lady and my lord wish to make two applications. The first application is to request for leave to appeal against your decision. My lord, my lady, I had previously prayed for on the 29th of May 2025 for the type certified proceedings with a view to appeal against that very decision, which has been referenced in your ruling. To date, I have not received a communication from the DR. Although it's administrative, that's part of the record. I rehash the same. Therefore, we pray for the typed certified copies of the proceedings so far in relation to these proceedings, with a view to appealing against the decision. Now, the last issue that I'd like to bring to the court's attention is that in our plea for the consolidation on the 29th of May 2025, we had sought that this petition be heard together, not separately. Together with, and I'm not asking that you revisit your ruling, which you rendered right now. Now it has come to attention that you have a mention for the other petitions. December 16th. We will humbly request that you give us a mention on that same day for good order. Thank you.
Now, Mr. Njeri, and what will be the purpose of the mention?
For this,
Because according to the record, what is pending now is your client's application dated the 20th of May 2025, which we are prepared to give direction. So we're wondering on the 16th, what is it that you want us to do?
now, in that application, we have served everybody
Yes.
in tandem with her leadership's direction. The letter dated the 4th of January 2025 from our leadership, the Chief Justice, when in the face of the decision of the Court of Appeal, which has been alluded to, for the recusal of this bench, we had indicated to her leadership that we had sought before her for an expanded bench.
Yes.
And she had indicated, as a record will bear in mind, as part of the expertise, make your application in the presence of the other counsel for the other consolidated petitions, so that this bench can consider the same, and then that decision can be made in the light of everyone's presence in the plea. So that, my Lord, just to answer you with tremendous respect, if this particular plea, I don't know if I've lost you, Judge.
No, it's okay. I follow you. Proceed.
That application cannot, in my humble submission, proceed absent compliance with her leadership, the Honorable the Chief Justice, direction to us that we make it before you in the presence of everybody else, whose decision, that is the bench decision, would implicate their petitions. That is the sole intention for that purpose. So that then our application, with tremendous respect, cannot be disposed of in the absence of everybody else that is involved in the other petitions. Lastly,
Now,
her leadership,
but,
may I say the last?
I'm just one of it.
Yes.
This issue you are canvassing, is it not part of the motion dated 20th of May? The issue of the expanded bench?
Yes.
It is, isn't it?
Yes.
Yes. So, if we deal with the application dated 20th of May, we will have taken care of the direction by the CJ.
I don't think
Because
so.
the CJ is saying,
Yes.
make your application for the expanded bench before your colleagues. And the issue of expanded bench is contained in your application dated 20th of May. So in essence, if we hear this one interpreted, then we will have complied with those directions.
But absent the other people? Absent the other
We
parties?
will give directions. Today we'll give you directions so that everybody who wants to participate in this application participates.
Oh, I'm sorry, my Lord, I misapprehended what you said. But to answer your query was based on why do you want to be there on the 16th of December?
Yes.
And I said, so that that particular issue you've addressed, my Lord, and thank you very much. I would then table it in the presence of my colleagues, and then we would canvass it, and everybody else confirms that I served them, and then we take directions from your lordships and my lady at that time. So that then the involvement of everybody that is implicated or somehow would be implicated in your decision, in my petition, then it would be fully participatory. And I'm saying that as I close, my Lord, please don't be patient, with respect. So that your Lordship, sorry, so that your Lordship, we save judicial time. We don't have a replication of representations before you. That's the sole reason.
Okay.
Thank
So if I get you right, Mr. Kindiki,
Yes.
you are requesting that we mention this matter on the 16th alongside the others so that between now and then you serve all the other parties with this application, then we take direction on that net.
I've already served them. Everybody's fully aware.
Very good.
So that your lordship then, because you asked me, why do you want to be included on the 16th?
Yes.
Why do we want to be part of the 16th? It's for that purpose. So that everybody comes on the 16th fully aware and live to the fact. The 20th of May application sought by Mr. Joseph Enokaura to have the expanded bench, as per her lordship's direction, is the sole issue that we want now to take directions on.
And those are directions we can give now, and we serve on the rest of the time.
I'd be happy.
We don't need to wait up to 16.
I'd be happy. It's only that you asked me why I want to be present.
Exactly.
Thank you.
So we will give directions on the application dated 20th of May 2025, and the Honorable DR will serve all parties who are participating, not only this petition, but the other related petitions.
Much obliged.
So the motion is dated 20th of May 2025, and these are our directions. The applicant's counsel, Mr. Nyandui, having confirmed service of the application dated 20th of May 2025 on all parties interested in the same, we direct that any respondent, either in this petition or in the rest of the matters, who is interested in pursuing or taking part in the application, shall file and serve their respective responses, that application, within 14 days from today. Once served, the applicant will be at liberty to file supplementary responses, if may be, together with written submissions on the application within 14 days of that service. Yes, let me that thereafter, the respondents to that application will be at liberty to file and serve their respective submissions within 14 days, and this matter or that application will be fixed for a ruling today without the necessity of parties highlighting. We shall give the...
My lord, I beg to highlight with
Yes.
your
Let me hear him first. What is it?
Yes, my lord. We were just concerned that my lords were issuing the directions before hearing us, but we are guided. The only issue, my lord, was we had an issue with mentioning this specific petition alongside the rest on 16th, because first, the principal parties in the other suits are the same parties in this petition. And the application dated 28th of May 2025.
If you have followed these directions keenly, you realize that this matter will not be mentioned on the 16th. Because the timelines we have given will go way past 16th of December. And we have said we will not give room for parties to highlight, you comply, file the submissions, then we were going to give you a ruling date today. So we are of the view as a bench that the matter, there's no point for this matter coming before 16th, because we have to determine this application path.
And my obliged.
Okay.
Yes.
So let's work on the timeline, then we see when you'll come for highlighting of submissions.
lastly,
Is that?
lastly, my lady, my
Oh,
lord.
yes, yes.
My previous pleas, I don't know if they will count. I haven't heard anything on it.
Yeah?
My pleas, the prayers for leave to appeal in the proceedings. I didn't hear it.
No, we will deal
Thank you.
with that.
Which is pending determination, and you have given leeway for parties who are interested in pursuing that application to participate in it.
Yes.
So I think it will only be fair that we communicate to our clients the position so that we can get instruction on whether to file responses and submissions. So I think it will be in order that we comply with those timelines as opposed to pushing, highlighting now without the benefit of all these other parties who could be interested in that application.
Mr. of January, I will be involved in the Court of Appeal interview. and you know how intense they are. So that I'm a bit apprehensive if we fix it for highlighting and with the necessity of me participating. I may make it depending on how that day will be.
Actually, Your Lordship, I wish you would make it. We need your and your Lordships. I mean, really, we need the minds with gusto in the court of appeal, like yours.
It's okay. Let's pray for the best.
Thank you, my lord, my lady. The 21st to the 6th of January is excluded time, so I don't know if it has been.
You have satisfied us and we have allowed you to highlight. We will do highlighting online on 26 February 2026 at 2:30 p.m.
The reason I was saying so, my board, is that occasionally, I'm not saying always, we have problems with.
But if there's a problem, the matter will be adjourned. But we will proceed virtually at 2:30 on 26th of February 2026.